When former President Donald Trump entered the Manhattan courtroom on charges of falsifying business records, the moment marked a historic first. No former American president had ever faced criminal prosecution. The 34 felony counts, unsealed in criminal court, alleged a scheme to conceal payments that prosecutors argued were designed to influence the outcome of the 2016 presidential election. Court reporters confirmed that Trump entered a plea of not guilty to all counts, a procedural step that initiated what would become one of the most closely watched trials in modern American legal history.
This is all of them, but John, what have you learned so far?
David, so far we have that this indictment includes 34 counts. They are 34 counts that are felonies, David, and they are falsifying business records. That indictment just unsealed in criminal court. Obviously, no one coming out just yet from those proceedings. They are still ongoing. But as we reported just a few moments ago, David, our understanding is that the former president has pleaded not guilty to all of those counts, David.
All right, so you've heard that from John Santucci. He's reporting 34 felony counts falsifying records. For those of us who aren't lawyers.
The Manhattan case, however, represented merely one chapter in a broader legal narrative that would define the Trump presidency and its aftermath. Across multiple jurisdictions and spanning several years, the administration accumulated a court record that legal scholars have since studied extensively. According to analyses of federal court data, the administration faced challenges to its policies at a rate that exceeded those of previous modern presidencies, with lower courts ruling against administration positions in approximately 6 out of 10 cases during the first term.
Donald J. Trump is guilty of 34 counts of falsifying business records in the first degree to conceal a scheme to corrupt the 2016 election.
That was Manhattan District Attorney Alvin Bragg speaking moments ago on the verdict in Donald Trump's criminal case. We continue to follow that breaking news tonight at 7. The former president has been found guilty on all criminal charges against him. Up until this point, Trump had pleaded not guilty to 34 counts of falsifying business records. It is the first criminal case ever brought against a former president who reacted to the ruling moments after it came down.
This was a rigged, disgraceful trial. The real verdict is going to be November 5th by the people.
To understand this record requires examining the specific mechanisms through which these legal challenges emerged. The administration's approach to governance frequently emphasized rapid policy implementation through executive action, a strategy that prioritized speed over what critics described as traditional administrative procedure. Within the first weeks of the presidency, executive orders addressing immigration restrictions encountered immediate judicial scrutiny. Federal judges in multiple districts issued temporary restraining orders, finding that certain provisions appeared to conflict with existing statutory frameworks and constitutional protections. The travel ban litigation illustrated this dynamic in real time. Administration officials revised the order multiple times in response to judicial feedback. Yet each iteration generated new rounds of legal challenges. Courts consistently identified procedural deficiencies, insufficient administrative record, inadequate consideration of statutory requirements, and in some instances, evidence of discriminatory intent that raised constitutional questions. While modified versions of the policy eventually survived certain legal challenges, the litigation created a permanent record of judicial findings that would influence subsequent cases. Perhaps the most significant early legal setback came in the Supreme Court's handling of the Deferred Action for Childhood Arrivals, or DACA, rescission. In Department of Homeland Security versus Regents of the University of California, the court found by a 5-4 margin that the administration's attempt to terminate the program violated the Administrative Procedure Act. Chief Justice John Roberts, writing for the majority, determined that the rescission was, quote, arbitrary and capricious, end quote, because the department had failed to provide a reasoned explanation for its action, particularly regarding the reliance interest of the program's recipients. The DACA ruling established a template that would recur across multiple policy areas, courts identifying procedural failures in the administrative process rather than ruling on the underlying policy merits. This distinction matters significantly for understanding the administration's legal record. The Supreme Court did not foreclose the possibility of ending DACA. Rather, it held that the administration must follow the procedural requirements established by Congress for significant regulatory changes. The ruling emphasized that executive power, even when pursuing otherwise permissible policy goals, remains bounded by statutory process requirements. Similarly consequential was the litigation surrounding the administration's tariff policies. The International Emergency Economic Powers Act, a statute dating to 1977, became the subject of extensive judicial interpretation when the administration invoked it to justify broad-based trade restrictions. Courts examining these actions found that the statute's language, which authorizes presidential action during unusual and extraordinary threats, did not clearly encompass the sweeping tariff regime the administration had constructed. The judicial reasoning focused on statutory text, legislative history, and the traditional understanding of executive trade powers under the Constitution's Commerce Clause. Legal historians note that these cases, considered individually, might appear as routine administrative law disputes. Considered collectively, however, they reveal a consistent pattern. Policies advanced through executive action without the procedural foundation that courts have historically required for durable regulatory change. The administration's approach generated what administrative law scholars termed a compliance gap, the distance between policy ambition and legal implementation. This gap, measurable in the volume of judicial reversals, became a defining feature of the administration's relationship with the federal judiciary. The composition of the federal judiciary during this period adds essential context to any analysis of these legal outcomes. By the conclusion of his first term, Trump had appointed 3 Supreme Court justices, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, establishing a conservative majority that administration supporters anticipated would prove sympathetic to executive power claims. This expectation, however, encountered a more complex reality as the court addressed cases on their substantive merits rather than through the emergency procedural mechanisms known as the shadow docket. Data on the court's emergency rulings reveals a notable pattern. The justices frequently granted administration requests for stays that preserve policies during pending litigation, suggesting a willingness to allow executive action to proceed while legal challenges unfolded. On the merits, however, the same justices joined opinions that upheld lower court findings of procedural or substantive legal violations. This distinction between procedural accommodation and substantive review illustrates a fundamental principle of judicial conservatism: respect for institutional process and textual statutory interpretation, even when such analysis produces outcomes that conflict with the appointing administration's preferences. Chief Justice Roberts' jurisprudence exemplified this approach. In multiple opinions, Roberts emphasized that judicial conservatism does not equate to reflexive deference to executive power, but rather requires rigorous application of established legal frameworks regardless of political context. His opinion in the DACA case articulated this position explicitly, noting that, quote, "The dispute before the court is not whether DHS may rescind DACA," end quote, but whether DHS chose to rescind DACA in a lawful manner. The answer to that procedural question, Roberts determined, was no. The cumulative effect of these rulings extended beyond any single policy dispute. In 2025, an internal administration directive instructed federal agencies to review existing regulations in light of recent Supreme Court decisions, citing 10 specific cases where the court had found administrative actions unlawful. This directive, while framed as routine regulatory maintenance, functionally acknowledged that a substantial portion of the administration's regulatory output had failed to withstand judicial scrutiny. The document, buried within routine Federal Register filings, represented an implicit institutional recognition of the legal record that courts had compiled. Legal scholars have debated the appropriate characterization of this record. Some emphasize that litigation volume reflects policy ambition rather than legal deficiency. An administration that attempts significant regulatory change will naturally generate more legal challenges than one pursuing incremental adjustments. Others counter that the reversal rate, particularly the consistency of procedural deficiencies identified by courts across multiple policy domains, suggests systemic institutional practices that departed from established administrative law norms. The Manhattan criminal conviction, delivered by a jury of 12 citizens following a 6-week trial, operated within a different legal framework than the administrative cases, yet connected to the broader pattern of legal accountability. The falsifying business records charges, elevated to felonies based on prosecutors' theory that they concealed election-related conduct, represented the first criminal judgment against a former president. Trump responded to the verdict with a statement characterizing the proceeding as politically motivated, a response consistent with his broader narrative regarding legal institutions. Independent analyses of the administration's court record suggest that characterizing these outcomes as purely political encounters significant evidentiary obstacles. The judicial appointees who authored or joined critical opinions included Republican nominees from multiple administrations, including the Trump administration itself. When justices nominated by the same president who advanced the challenged policies find those policies legally deficient, explanations based on partisan judicial bias become less persuasive than institutional analyses focused on legal methodology and administrative procedure. The long-term significance of this legal record may lie less in any single ruling than in the precedential framework established for future administrations. Courts addressing executive action now operate within a landscape shaped by these decisions. Clarified standards for administrative procedure, refined interpretations of emergency powers statutes, and reaffirmed principles that executive policy implementation must follow congressionally established processes. These precedents bind future administrations regardless of party affiliation, creating institutional constraints on unilateral executive action that will persist beyond any single presidency. For the American legal system, the period represented a stress test of institutional independence. The federal judiciary, including justices appointed specifically because of their conservative jurisprudential commitments, demonstrated that judicial philosophy and partisan political alignment remain distinct categories. The rule of law, as articulated through reasoned judicial opinions applying statutory text and established precedent, functioned as a constraint on executive action that transcended the political preferences of individual office holders. Whether this institutional resilience will persist through future political cycles remains a central question for American constitutional democracy. The Manhattan verdict, delivered in a state courtroom rather than a federal administrative proceeding, concluded one chapter while leaving others unresolved. Multiple criminal cases remained pending in federal and state jurisdictions, their outcomes uncertain. The legal principles established during the administration's tenure, however, had already entered the permanent record of American jurisprudence, available to future litigants, future judges, and future administrations confronting the enduring question of how executive power operates within a system of separated powers and judicial review.